Good afternoon and hello out there in webinar land. And thank you for joining us once again for our OG Energy Education series. I am Brad Gibbs speaking today. And once again, just glad you are all here. Today's topic is titled Navigating the Crossroads. And I'm going to be talking about the evolving surface use issues and innovative solutions surrounding the intersection between oil and gas and renewables. This has been a topic I've been asked to speak on quite a bit lately. And if some of these slides look a little bit familiar to some of you, it's because I have blatantly plagiarized myself and cannibalized a previous presentation I gave to put this one together. But I hope that there will be some new and interesting information, especially towards the end. So if you've seen a lot of what's in the first half, feel free to close your eyes and just take a little snooze through the first 20 minutes or so. So once again, the overview here is that we're going to talk a little bit about kind of what topics I'll be covering today. And we're going to talk a little bit about mineral severances, the dominant estate theory, the accommodation doctrine, the Midway solar case that I've talked about a bit before that keeps coming up in relevance. I'll talk a bit about accommodation agreements, waivers. I'll touch on the Texas qualified subdivision statute. And then I'll close out with some best practices for really both the renewable developers and oil and gas practitioners. This topic has, like I said, has been coming up a lot lately. I've been involved in a number of these deals, these negotiations, representing both solar developers and oil and gas companies, mineral owners, operators, various types of interest holders. And there's still a lot of question marks surrounding kind of how this is going to look going forward. But the fun part is it's also an application of a lot of very traditional oil and gas law doctrine. So it's fun to see the way that this is evolving over time and the different approaches different companies are taking and their risk tolerance. Again, I'll be talking a little bit about sort of how the development of renewable energy sources can affect oil and gas operations, the implications on the oil and gas industry, and the applicability of a few different legal doctrines. Towards the end, I'm going to get a little bit more into maybe the academic side of where this could be going, which will include what do you do about executive right holders, non-executive interests, and where title insurance policies kind of fall within this whole area. So mineral severances, I have a feeling everybody on this webinar is very familiar with this concept and this term. Obviously, ownership rights in tract of land are commonly split between the surface estate and the mineral estate. And in Texas and in many other jurisdictions, we don't have the idea of mineral servitudes like you might run into in, say, Louisiana, or even in Texas, a dormant mineral act that might reunite these interests with the surface based on a couple of different mechanisms like prescription or the passage of time. So here you can have very old mineral severances that are outstanding that you have to deal with. And these people may have disappeared a long time ago. Some of these mineral severances could have happened well over 100 years ago. So the owner of both the surface estate and the mineral estate can sell, convey, or partially convey the rights to either the surface or the mineral estate. And of course, selling one but not the other is what creates a mineral severance. So if you own fee simple title to the surface and the minerals, you sell the minerals, that's your mineral severance. So once you've got this mineral severance, you get into this idea of what's commonly known as the bundle of sticks, something else that you guys have all certainly heard of. And this is the various bundle of rights that you have as either the surface owner or the mineral owner. These are pretty well established. Courts are going to look at this, the same way across many different situations. And you'll see this language pop up in a lot of court opinions and a lot of legal analysis. So the surface estate owner, of course, has the right to use and enjoy the surface, except for any surface rights that happen to belong to the mineral owner. And the mineral owner, of course, is going to have certain rights to use the surface to develop their minerals. There's a lot of public policy involved here and sort of legal policy that's developed over many decades in Texas and elsewhere. So what the mineral owner is going to get when they're conveyed a mineral interest is the right to royalty, the right to receive a bonus upon executing an oil and gas lease. Delay rentals, you don't see them as much anymore outside of certain federal or possibly state lease contexts. Most leases these days are paid up, but this is still one of the rights in the bundle. The executive right is, of course, the right to execute an oil and gas lease. And you're also going to have this right to develop the minerals, known as the developmental right, the right of ingress and egress. So this is this kind of implied easement to enter upon the surface and use as much of it as is reasonably necessary to develop your minerals. I emphasize reasonably because that's going to come up quite a bit here. The executive right owner that I'll touch on a little later in this presentation, of course, has that right to lease. Often, if you've got the executive rights, you may also have received the developmental rights as well. The two are considered fused unless they're kind of specifically separated. So now I'm going to get into the dominant estate theory. And under this theory, when the mineral estate is severed from the surface, the mineral estate is considered the dominant estate, and the surface estate is considered to be the servient estate. Now, these are terms that sort of originated under the law of easements. And the idea here is not so much that the mineral estate has, completely superior rights across the board. It's more of the idea that it creates this dominant right to use a portion of the surface, and the surface is kind of servient to that or is burdened by that interest, very similar to the idea of an easement to cross your land. So what this means is that the mineral estate owner can make reasonable use of the surface to develop their mineral acreage without being a trespasser. So you are going to have the right to enter the surface and, conduct oil and gas developmental activities. So here's a little preview for the Midway solar case. In that case, a 1948 mineral deed gave the mineral owner the right to use as much of the surface as was usual, necessary, and convenient. So when courts are looking at this language, they have to look at the language as it, what it meant, what the parties intended in the context of the time and what, these rights were created. So some questions come up that become relevant to Midway solar as to, what part of the surface can be used for development or could potentially be used. Did it implicate vertical drilling, horizontal drilling? Obviously in 1948, horizontal drilling, was really not even on anybody's radar. It was science fiction at best. So this gets into this idea of reasonable. It's always a dreaded term in the law because anytime the word reasonable pops up, what it really means is that there's a lot of arguments that can be made and a lot of facts that are going to come into play. So reasonable use generally, and this is based on various cases over the years, it's going to include things like geophysical exploration, seismic drilling, building roads, installing machinery, storage tanks, batteries, things like that. There's also this general duty to act as a reasonable, prudent operator under a lease. This is an implied covenant under the lease. It kind of oversees the various other implied covenants. And no matter what, you're always going to be expected to act as a reasonable, prudent operator. I'll explain a little bit later why I think that's important in this context. But for now, just understand that that's another kind of reasonable analysis that goes on here. So is that everything? Is the dominant estate all powerful? Spoiler, it is not, obviously. But if you're the mineral estate owner, you have the right to reasonable use of the surface, and you can use that surface to develop your minerals. So that, of course, brings us to the Accommodation Doctrine. And any, first year oil and gas practitioner, landman has heard of the Getty v. Jones case. And this case is really the birth of the Accommodation Doctrine, where it really solidified Texas courts' approach to this doctrine. The facts here that I think help understand the context a little bit are that Getty had installed a pump jack to produce oil from Jones's land. The pump jack was about 17 feet high and interfered with Jones's irrigation operations. He had what's I think commonly known as a kind of center pivot irrigation system, where it would basically roll around in a big concentric circle, watering his crops. Obviously, if you put something 17 feet high in the middle of that circle, it's going to interfere with the travel of this irrigation system around its normal course. And this is going to be a very expensive problem for somebody like Jones to have to rectify. So obviously you're getting into this reasonable, analysis now. So what the court found is that Getty didn't really have the right under the dominant estate theory to put its pump jack right there. Jones had been using this. It was imperative to his ability to make a living, to, get reasonable use and enjoyment out of his land. And they found that, importantly, Getty had a reasonable low cost alternative to the pump jack. Now, I've always found the court's reasoning here to be a little bit interesting, because what the court says is, well, you could have dug, a hole deep enough, put your pump jack down in a hole and have the irrigation system pass over it. Now, digging a hole, having an irrigation system coming over your hole that sprays water into your hole seems like not a great solution to me. I don't know if that's a reasonable low cost alternative or not. At any rate, that's what the court said. Getty lost and the accommodation doctrine took hold. So under the Getty Oil rule, if the proposed use of the surface by the mineral owner will substantially impair existing surface use, like an irrigation system, and the mineral owner or its lessee has reasonable alternatives available, like they said Getty did here in digging their hole, they may then have to accommodate the surface owner. It doesn't even mean they have to. It means you get to move on to, really arguing the facts and figuring out how this is going to play out. So after many years, I'm not going to walk through all the various cases applying the accommodation doctrine. This is kind of where we stand today. So the surface owner has to have an existing use. And this is also going to be a very important point for solar developers that I'm going to talk about a little bit, because you don't want to just go out, and kind of willy-nilly build your facility and say, well, we've got the accommodation doctrine. It's an existing use now. Well, that doesn't necessarily apply right out of the gate. It strengthens over time. But, if you do have a use that's been there for many years, like Jones's irrigation system, then that argument's really going to come into play. The proposed use by the mineral owner has to completely preclude or substantially impair the surface owner's existing use. Again, think about Getty. The surface owner has no reasonable alternatives. So in other words, Jones couldn't just go build a 20-foot tall irrigation system. He couldn't move his crops. He couldn't, really move his irrigation system or come up with an alternate irrigation system. So again, the surface owner has to have no reasonable alternatives, and the mineral owner has to have alternative, reasonable, customary, and industry accepted methods available to develop the minerals. Again, back to Jones, apparently digging a big hole, but that's enough about that. So I note at the bottom, the accommodation doctrine may strengthen over time or after a service facility is in use or in existence for, a while. So when does it become an existing use? Well, great question. If you were wondering that, the answer is nobody really knows. This question has never been resolved by the court. It hasn't really been litigated, or at least not much. But, I think it's important to a solar developer, especially if you're looking around right now going, wow, we never got any agreements from mineral owners. We've had this solar facility that we built 2 years ago. Are we safe now? Yeah, maybe, probably. I don't know. But there must be, at least some significant period of time that's passed. And you have to remember, there also has to be no reasonable alternative to the service use. This can get you in trouble too. A court could say, well, a reasonable alternative is you move a portion of your solar facility or you remove a portion of your solar facility. And again, accommodation does strengthen over time. We don't really know how much time, but the more, the merrier. This is going to be fact intensive, which is why the thread that you're going to see running through this presentation, the general advice that I'm going to be giving is figure this stuff out on the front end so you don't get to this. You don't have to deal with these problems. But it seems clear that the accommodation doctrine is more of a shield than a sword. Its, intended use is to protect you if you have been using the land for a while, if you've been using the service for a while, not to say, hey, we're going to go out and spend millions of dollars building a facility and then just assume the accommodation doctrine is going to protect us. As you will see in Lyle, they did win on that argument, but they got very lucky, and I'll explain why. So in Lyle versus Midway Solar, this is a case that came down a couple of years ago and was still sort of pending in front of the Supreme Court as recently as last summer, where it finally got more or less disposed of, which I will discuss. So here, a renewable company constructed a solar facility which covered 70% of a 315-acre service estate. Interestingly here, and this is part of the reason that I think Midway Solar got very lucky, oil and gas had never been produced on this tract. This becomes very important. It was a complete dead zone. There was really nothing going on around it. Nobody had ever tried to lease this land. They had never tried to market the Lyles had never tried to market their mineral interest, et cetera. You know, good luck encountering this exact set of facts in a lot of other legacy producing areas in Texas. Do great. Maybe you can rely on the Lyle case, but again, I think they got very lucky here. So again, I mentioned this 1948 mineral deed. They sued for, a breach of what's usual and kind of reasonable use under that deed. They sued in trespass. They sued under the Accommodation Doctrine. And there was a quiet title angle too, which really had to do with the fact that that Midway had actually gone and obtained some surface waivers from some mineral owners in adjacent tracts. These adjacent mineral owners erroneously claimed they owned some minerals in our 315 acres. It turned out they did not. So the quiet title was to remove that cloud. And it turned out that Midway had not obtained surface waivers from anybody who actually owned an interest in this tract. Ultimately, they were suing for monetary damages, in the full amount of the lost value of their minerals and or removal of the solar facility. So obviously catastrophic results potentially either way. So to kind of let you know what this looked like, here's an aerial photo of the solar farm. They let these kind of, let's call them end zones at either end of the facility. And much like the Houston Texans, the Lyles had very little use for these end zones. And you'll note that there's no room for drilling at the center of the solar facility. And what really happened here was a battle of expert witnesses. The Lyles came forward and said, if you look around at the historic trend line, there's really only been vertical development here. Nobody's going to come in here and drill a horizontal well. You left us these end zones, and the only real practical use, if they were even big enough, would be to come drill horizontally here. It's never going to happen. They got their expert to testify that the only reasonable place to put a well would be right smack in the center. And they said, but we can't do that. Therefore, you've, for all practical purposes, destroyed any potential value of our minerals moving forward. So the plaintiff's argument was, again, they have no ability to develop their minerals, and their rights have been impaired by the solar facility. And they say under the Accommodation Doctrine, they should be able to prevent any surface use that may one day interfere with extraction of their minerals. This is also kind of an important, argument in this case, because the Lyles are essentially making a forward-looking argument. They're saying, well, yeah, maybe we've never done anything with our minerals, but if we wanted to one day, now we can't. And therefore, you have to pay us. One could argue that they were really essentially trying to extort Midway Solar to squeeze some value out of these otherwise valueless minerals that nobody was ever going to buy or lease, develop, and they just saw an opportunity. But, that's off the record. Defendant's argument was that the mineral estate owners have never once tried to develop their minerals. They've never done anything. This is all speculative. Why are you bringing this now other than to try to extort us for money? And in addition, they say we did leave land available for oil and gas development. We left you your little end zones here. So the Court of Appeals said, look, until the Lyles seek to develop their minerals, Midway owes no duty to the Lyles respecting the surface use. They said, look, this is not right for argument at this point. The Lyles have to seek to do something. So obviously, the theory of the dominant estate is not absolute. So there's a question here. Is there some kind of affirmative action required to protect your dominance then as a mineral owner? Are we saying then that that's something you have to do here under the Accommodation Doctrine? Unclear. But what we do know is that the mineral estate owner does not have the unilateral dictate the use of the surface. The court also says, yeah, the Accommodation Doctrine does apply, but we're not going to apply it because it's not right. So they essentially punt, shall we say, again, something the Texans are very fond of doing on this issue. And that brings us to the Supreme Court. So they go to the Supreme Court and they bring up several additional issues at the Supreme Court level. And the first is, again, whether the petitioner's various claims are right. Is there this use it or lose it kind of idea running through this? And also whether the accommodation doctrine is independently worthy of review. So what they're really arguing here is whether the claim was ripe or not, and whether the court should have applied the accommodation doctrine instead of just saying, well, it's not ripe at this point. Some of the arguments they made, pretty good arguments were that there was no consultation with the mineral owners on the drill site locations. This was true. They had just decided where they were going to go. They didn't get any agreements, any waivers, didn't even ask, no geological analysis. So there's sort of not this good faith effort of, hey, we looked at the surrounding, historic trend line. We looked at the kind of geology of the area, and we made at least some decision based on some facts about where we thought it would be reasonable to put future drill sites. None of that happened. They said, look, the drill sites are small, they're unobstructed. Vertical drilling right in the middle would have been the best way to approach this prospect. And they ended up, and they argued for a catch-22. They said, well, look, we can't develop the minerals now because the minerals can't be developed. So what are we supposed to do here? We were given no due regard, and you've rendered our minerals virtually useless. So anyway, the Supreme Court decided not to weigh in on this. They denied the petition to review first on November 19th of 2021, and then again in April of 2022. And the framework here, what we came away with in this case was that we have a framework now for analyzing these situations. We know that the accommodation doctrine is going to apply. We also know that there are these other facts at play, and you're going to have to look at things like, what's happened in the past with the minerals, what's going on around the mineral before you decide, hey, we're not going to bother to get accommodation agreements or surface waivers, which in many areas of Texas is a fairly risky proposition if there are severed minerals. And also, you can avoid all this by reaching an agreement beforehand. So let's talk a little bit about those agreements. There's kind of two general types of agreements that have emerged. These terms are used interchangeably. I use them here loosely to draw kind of a distinction between two types of arrangements. I've been involved in negotiating both. And the first is a service waiver. And a service waiver, the way, we tend to approach it is it's going to be very broad. It's a voluntary agreement between the surface estate owner and the mineral owner, or the solar developer and the mineral owner, that governs the relationship between the parties. Usually broader than an accommodation agreement. These are often negotiated once there's an option to purchase the surface in place. Early on in the process, you start looking at these, and oftentimes the deal closing will be contingent on getting these service waivers, or at least a percentage of them. And again, the idea of a service waiver is it's very broad. We're giving up all of our right to use the surface, period. They're short, they're sweet. Oftentimes, the best option if you're the solar developer. Now, what often happens, particularly if it's an area where there's a lot of historic production or some current activity, you're going to be negotiating an accommodation agreement. These are going to be much lengthier, much more heavily negotiated. There's going to probably be a considerably large price tag attached, and they're going to have a lot of unique terms in them. Some of these may be drill pad size, location, shared use of roads, notice of operation, consents. You're going to need to access and take away easements. Other facilities may be taken into account. And under either of these agreements, the mineral owner, after signing it, is going to be preempted from interfering with operations on the surface. So that's what you get from this. The mineral owner waives their right to bring a Lyle style suit. And this is going to prevent the mineral owner from asserting their rights either under the dominant estate theory or under the accommodation doctrine. And like I said, will likely require a payment of some form to secure the agreement. This may vary considerably depending on kind of the actual value of the minerals as determined by someone, maybe the owner, maybe a third party, maybe lease bonuses in the area, things like that. Operators or mineral owners are under no obligation to sign one of these. So if you approach a mineral owner or you approach their lessee, they don't have to sign this. I mean, they can tell you to take a hike. They often do. Unfortunately, if you're the solar developer. So recently there was an interesting deal that came up and got a little bit of press. And this was the Blackstone Longroad deal. And, this is an interesting deal, kind of a groundbreaking deal, because it dealt with this idea of a blanket accommodation. So in mid-July of this year, Blackstone Minerals announced a multi-year deal with Longroad Energy, who's a renewable developer, for exclusive access to several thousand acres across 12 states for potential large-scale solar development. So they said, look, we're going to negotiate a huge accommodation agreement, or at least an agreement to negotiate exclusively accommodation agreements with Longroad. And Blackstone's position was, well, look, this secures our ability to develop the minerals while taking advantage of all the money that's being, allocated to solar development. So for Blackstone, this is really win-win. They get paid to enter into this deal. They get paid most likely on a prospect basis, and they get the promise of an accommodation agreement where they will be able to develop their minerals in the future, and they have to agree to it. They said in the press releases that this allows the parties to transact efficiently and repeatedly. As my graphic there displays, some might say that the two are now in bed together. And, the question I think is this the future of renewable development, these large institutional mineral investors? I mean, this is kind of a first of its kind deal, or at least on this scale. And, again, it's good for Blackstone. It locks in solar development revenue for them moving forward, allowing them to still access their minerals. Though almost immediately, there were some rumblings about whether this is potentially an anti-competitive type deal, an antitrust deal. I mean, is this, impeding progress? Is it impeding the ability for other developers to come in and negotiate fairly in an open market? As of right now, the deal stands and has not been challenged or anything like that, but an interesting deal with some interesting potential and some interesting issues surrounding it. So this brings us to, another interesting idea in waivers and accommodations, which is who needs to sign these things. And this is the subject of a lot of heated debate. People feel very strongly about this. Now, you're dealing with different types of owners. If you're out running title on the mineral estate as a solar developer, figuring out who owns what and who you're going to need to approach. You've got your basic mineral owners. You might have non-executive mineral interest owners. You might have non-participating royalty interest owners. You might have lessees. They're under lease. You might have mortgagees who have an interest in the minerals. They may have a mortgage on the minerals. And what happens if they come in later and foreclose? Would that potentially foreclose upon your accommodation agreement as well? Just some interesting ideas. I'm not saying I have the answer, but I will say that there is certainly no statutory subordination for accommodation agreements like there is now for oil and gas leases, at least in Texas. So moving then on, we've talked quite a bit about mineral owners and kind of why you would want to get them to join in one of these, but let's talk for a minute about NEMIs and executive rights. So an executive right holder owes a duty of utmost good faith and fair dealing to non-executive right holders. Now, courts have said, look, this is a heightened duty, but it's not a fiduciary duty. So they don't have to put the non-exec's interest ahead of themselves, like say a trustee or an executor of an estate would have to do, but they can't blatantly self-deal. So they can't take something for themselves to the detriment of their non-executive interests. So this applies to MPRIs and NEMIs. So think about the circumstances where you approach a non-executive mineral interest owner, they waive rights. Let's just say they execute for a pretty penny, a full surface waiver, and their non-execs now have no continuing right to develop their minerals. The executive right owner pockets this money, doesn't give any of it to his non-execs. They may not be happy about this. There could be a breach of this duty up to and including having the agreement set aside. So the best practice here would be to probably have the NEMIs also execute a waiver. In theory, this could extend to NPRIs as well. As far as I know, nobody's out trying to get accommodation agreements from NPRIs. But again, they could argue that their value has been essentially destroyed by by executing this, and they could theoretically have standing at least to bring, a grievance. And this brings up another kind of interesting idea, which is what about if the minerals are under lease? What do you have to do then with this lessee? And is there any continued duty to approach the mineral owners who are under lease as well? Well, these are great questions. So first of all, you have to look at what is the duty of a lessee to a lessor? Really none, other than they have to act, and I mentioned this early, as a reasonable, prudent operator, the RPO, as it's called. So if the minerals are under lease, do you only need to get the signature of the lessee? This is a fairly common practice. Many solar developers take this stance. I think even some title insurance companies, are okay with this, but it may depend on the circumstances. So remember that an oil and gas lease is both a contract and a conveyance. It creates a fee simple, determinable estate with what's known as a possibility of reverter. So that means if, operations never commence, development never commences on the lease, it's going to revert to the mineral owner at the end of its primary term, or if it's in its secondary term, production ceases, or a number of other, contingencies happen, and the lease expires. Again, it's going to revert back to the mineral owner. So here's kind of a hypothetical, and I pulled this out of, kind of piecemealed it together out of a number of these different types of questions I've had and negotiations I've been in. So, it's not to say that you're going to run into this exact situation, but I think this helps sort of demonstrate some of the points that I'm trying to make here. And so let's say here we've got an operator O who has 100% of the working interest under Black Acre and White Acre. So lease 1 and lease 2. And these tracts have been pooled. So we've got a single old marginal stripper well, been producing for many years. Very possible this well is going to stop producing entirely soon. It's down to a trickle. These leases may not make it through another year. And the operator, not a lot of potential here, not a lot going on in the area. They're not really planning to do anything. They're not planning to drill any additional wells. They don't really care too much if the lease is maintained or not. Let's just say it's a high cost, tight shale designated area in Texas, to add a little bit to a lot of little color. We'll say there's a little permitting activity nearby. Nothing on the land directly, but there's some people drilling some short laterals in the area, a little bit of marginal activity going on. So the solar developer now approaches operator with an option to lease White Acre. So this is the non-productive pooled tract. They go out and run title and discover O's lease on the minerals, and they approach them. So solar developer has an option to lease the surface of White Acre and approaches O to negotiate an accommodation agreement covering the area of interest for its proposed solar facility. So they're saying, look, we want to build this solar facility. We're trying to cross our T's and dot our I's. We want to get an accommodation agreement. You're the lessee. We're going to negotiate with you. So the solar developer does not then approach the mineral owners, believing that obtaining a waiver or accommodation from the lessee only is sufficient. So what's the issue then? Well, I got a whole laundry list of potential issues here. The first question is, should the solar developer obtain accommodation agreements from both the mineral owner and its lessee? Well, what duty runs from the operator to the mineral owner? We talked about that. Reasonable, prudent operator. What duty runs from the solar developer to the mineral owner? Well, it's to allow them such use of the surface as is reasonably necessary to develop the minerals under the Accommodation Doctrine. So then what standing or remedies might the mineral owner have, in this type of situation? Also, what incentive does the operator really have to negotiate a fair accommodation agreement, taking into account the fact that these waivers or accommodations may very well outlive an oil and gas lease? What do they care? They have a year left. This is an opportunity for them to get a little bit more money out of this prospect. Sure, we'll sign your accommodation agreement. Yeah, this looks great. They don't even really look at it very closely. Does it matter whether the lease is in its primary term, may never be developed, or near its end, or in the middle of a robust development program? So I'm going to call this the life cycle argument. If there's a chance the lease may never be drilled, then there's a fairly good reason that you might want to get accommodation from the mineral owner. Or if you know the lease is very close to the end of its productive life and there's no real plans for future development, again, you may want to approach the mineral owner and have them sign off on this as well. But, if this is just a booming area, they're blowing and going, they've just drilled a bunch of great wells, maybe there's more of an argument for just getting accommodation from the lessee. So, could there be a difference if development or permitting activity in the area is horizontal or vertical? The point I'm trying to make here is back to Lyle. It's where would you need to put surface locations for future drill sites? If it's horizontal, you've got more flexibility. Vertical, you're going to have to look at the spacing pattern and figure out, well, where would the vertical well most likely go on this tract? So the most likely outcome is that the dispute would ultimately be between the solar developer and the mineral owner. However, the best practice for a lessee or solar developer may be to have the mineral owner sign off along with the lessee. Again, probably more important to do this if the lease is still in its primary term and may never be drilled, or a producing lease or unit is kind of nearing the end of its productive life. There's just nothing really going on in the area. And the point here is that a mineral owner standing to challenge a lessee's signature may increase depending on how remote possibility of their reverter may be. Otherwise, the lease conveys a fee simple determinable, and arguably the lessee has the right to do whatever they want. So then, does the lessee need to be worried in this situation? I've been kind of talking a little bit about why the solar developer might want to get the mineral owner to sign off, but what about the lessee? So holding a lessee liable, and this would be the mineral owner holding the lessee liable, seems to be somewhat of a remote possibility, but it's possible that a mineral owner could argue that a lessee waiving service rights for a solar facility for its own benefit might exceed authority under the lease. I mean, what does this have to do with oil and gas operations? Are they acting as a reasonable, prudent operator? Could be a valid cause of action for failure to act as a reasonable, prudent operator. Pockets the money. And again, building the solar facility really has nothing to do with reasonable use of the surface to develop the minerals. There's also an argument that the accommodation agreement would only curtail the lessee's rights. So you're saying, hey, lessee, you're kind of agreeing as to where you think this facility should be and where we should put drilling setbacks, et cetera. There's an argument to be made here that whatever the lessee signs may not survive the lease. And in many instances, these solar facilities will be around for many years longer than there could be production on the lease. Sometimes, not always, it just depends. But could you get in you signed this last year, your lease expired, any rights you ever had have now terminated, and your agreement did not survive this lease. So now note, if your facility has already been built, you're going to get into an accommodation doctrine analysis. You're going to look at has a reasonable period of time lapsed and things like that in deciding whether or not the accommodation doctrine applies and how it will apply. And, if the service owner has signed off and the facility's been there a while, the accommodation doctrine is going to offer more protection. So, just a little bit more about this idea of lessee liability. You may be okay negotiating with a lessee if it's kind of a good faith negotiation, because again, the accommodation doctrine is a balancing act. It's meant to look at, are everybody's rights ultimately being protected? So, if there is some basis in reality to where you decided to put the setbacks, did you allow for reasonable access and takeaway capacity, things like that? The mineral owners may ultimately lose because they have been reasonably accommodated, but to get there, I think there's got to be at least some good faith negotiation. It can't be like what I was saying earlier. You just sort of sign off on this thing, cash the check, and go on your way. You may be exposing either lessee or solar developer may be exposing themselves to a future liability. But if it's truly fair, based on some assessment of development in the area, the mineral owner's standing is going to decrease. So, there's an argument that if the operator only signed the accommodation agreement to squeeze a little more value out of the prospect, there was no true negotiation. You could be looking at unjust enrichment, money hadn't received, you didn't share those proceeds, even possibly conversion, breach of contract, a number of different arguments, legal arguments that could potentially be made. Okay, so moving on, changing gears a little bit, I'm going to jump over and just talk about some interesting, less spoken of aspects of Texas law, one being the Texas Qualified Subdivision Statute. This is an exception to the common law accommodation doctrine. It provides a procedure for owners of the surface to limit mineral owners' use of the surface, delegating administration to the Railroad Commission. So essentially, under certain circumstances, you can go to the Railroad Commission and have them kind of mediate an agreement. You have to file a plat for approval with the Railroad Commission and in the county. The statute states that a single tract can't be greater than 640 acres, though we'll see in a minute that occasionally you can put two contiguous tracts together. It has to be in a county of at least 400,000 residents or in a county adjacent to a county with 400,000 residents that has at least 140. It has to be for residential, commercial, or industrial use. There has to be at least 2 acres setbacks for every 80 acres and allowances for road and pipeline easements and access. The Railroad Commission will then have a hearing to consider the adequacy of the operation sites and road and pipeline easements. And, note that this 140,000 residency requirement limits you to only about 35 counties in Texas-ish. And the reason I think this statute's interesting is because I think it gives you, like, let's say you are negotiating a accommodation agreement with a lessee, and you're sort of saying, well, do we think this is reasonable? Is this good faith? Well, I'd say, at the very least, you'd probably want to comply with these types of standards. Are there at least a couple acres or more setback for every 80 acres? Are there road and pipeline easements, access, all of these things? And the statute at least kind of lays out, I think, some minimum guidelines. Not that I would rely on this exclusively. It's going to, depend a lot on the individual circumstances, but, kind of an interesting floor, at least for analysis. There's one case out there that kind of interprets this statute. And here, Swebby took issue with the fact that the Railroad Commission had allowed 2 contiguous tracts to be developed for a landfill. Their big argument was that, A, you can't do this on 2 contiguous tracts. The statute says you're limited to 640 acres. They also tried to argue the landfill was not an industrial use. They got poured out on both arguments. The court noted the statute's intended to maximize both surface use and mineral use in population dense areas. Okay, great. But it's not too much of a stretch to imagine a solar facility being an industrial use. I mean, if a landfill is, I'd imagine a solar facility might be and might fall within the meaning of this statute. Otherwise, other than this Texas Qualified Subdivision Statute, Texas has very little in the way of any kind of mineral condemnation outside of the Accommodation Doctrine. So for any of you out there saying, well, why can't we just go, basically, we're a common carrier, why can't we use eminent domain? You really can't in Texas in this type of situation. You can't kind of foreclose under eminent domain on the mineral estate in most instances. So what then are the best practices for energy companies? And by this, I mean really solar developers. First of all, where you can focus on low value acreage where there hasn't been a lot of oil and gas activity, I think your risk tolerance starts to go up considerably in these areas. Create agreed upon, and I have to emphasize this so you don't fall into the Lyle trap or the Midway solar trap, agreed upon drilling areas or islands within the projects in the event oil and gas is discovered. Pursue surface waivers or accommodation agreements and limit the number of drilling islands. Avoid tracts that have multiple severed mineral interests. This can be very difficult in Texas, really very difficult in any major oil and gas producing area across the country. And look, if you've already built your facility and you're panicking right now, remember, if it's been a while, you probably are going to have some protection from the Accommodation Doctrine at this point. And hey, nobody's challenged you yet. Maybe you're in reasonably good shape. So putting it all together, you want to avoid triggering Accommodation Doctrine issues by, again, obtaining these surface waivers or accommodation agreements, build solar and to some extent wind facilities in areas that have not seen as much development. Look at the production, look at the Railroad Commission website. Are there, you may even fall within Rule 37, Rule 38, Rule 86. you may be looking at a spot that's not even a legal location, and in which case you're fairly well protected. And a few other considerations. Remember that oil and gas owners are under no obligation to sign a surface use agreement or waiver. It's probably going to require you to throw some money at the problem. I heard somebody describe it as money whipping the problem the other day. That was pretty good. And the best practice is going to be obtain surface waiver agreements from all of the mineral estate owners, their lessees, possibly their non-execs. Again, depends on your risk tolerance. Minimum requirements: look at the county records, check for fractional mineral estate owners, determine if you want to take the business risk of not obtaining waivers from all parties. Okay, very quickly, I know I'm getting a little short on time here. Let's talk about a title insurance policy, aka the T19 endorsement in Texas. So some title insurance policies provide title endorsements that may give solar developer or its financiers some protection from oil and gas development. So you may be able, depending on the size of the policy, these policies can get quite expensive. You may be able to protect yourself a little bit from future issues with the mineral estate. However, your title insurance company is not going to like an accommodation doctrine argument. They don't even like those words. Don't even mention the accommodation doctrine. What they're going to want to see is at least a certain percentage of the mineral. One question I get is, well, what is that percentage? Well, it depends on your title insurance company. I've seen it anywhere from 50% to 85%. A sweet spot seems to be around 65%, maybe up to 75%, but again, ultimately that's going to depend on your title insurance agent and company and their kind of policies. And so, remember also that title insurance companies don't specialize in identifying proper parties. They're not really mineral title. They run very quick and dirty kind of surface title checks. They look for very specific issues. They don't like quick claim deeds, for example, things like that. But they really are laymen when it comes to the minerals. You're going to want to go out and get a good broker to run the minerals and work with you on this stuff. So remember, such policies insure only the value of the underlying real estate rights and improvements up to the actual amount purchased. So if you want that coverage, you're going to pay dearly for it. So conclusion, and I think, yes, this is my last slide. The dominant estate theory is a powerful tool for oil and gas operators in Texas. It's not absolute. You don't want to rely on this, across the board for all situations. Renewable energy companies should be, cautious about relying on the accommodation doctrine. The only way to ensure a mineral estate owner cannot assert their rights is to get that surface waiver agreement or accommodation agreement. Executive right owners should be careful to avoid breaching their duty of utmost good faith and fair dealing. You may want to get waivers from the non-execs as well. I know a lot of you don't like hearing that. It is advisable to consult with an experienced oil and gas broker and, of course, a law firm. Got to give myself a little pitch here. When you run into these issues, reliance on a real estate commitment or pro forma is not, sufficient to identify the mineral owners. You don't want to run out based on their quick check and they're like, hey, we saw a couple of leases here. You're probably not looking at everything. And, those documents are not actually required to include mineral rights at all. You want to make sure you're obtaining agreements from the right mineral owners, their lessees, and their non-execs, or, some combination thereof. So quickly before I end here, I think I was supposed to do this at the beginning and I failed to do so. For those of you who aren't familiar with our programs, you'll receive an email over the next couple of days with accreditation information, how to claim your credits and everything. I think we're pending credits from a couple of organizations right now. So once we have all our ducks in a row, don't call us, we'll call you, save you the trouble. And we will send you those links sometime in the next couple of days. That is it. I really, once again, appreciate everyone joining us today. It looks like we had great attendance. Clearly, this is a topic that garners some interest from folks. And I promise next time I speak, I will come back with some new slides. But for today, that is all. Have a great rest of your week, and we will see you next time.